У нас сьогодні є і ключовим нашим гостем є представник такої далекої, такої близької Канади, то я дозволю собі перейти на англійську мову. Dear friends and colleagues, I am very glad as a director of the law school and on behalf of the team of the UCL Law School to welcome you all here today at the Sheptytsky Center of the Ukrainian-Catholic University, and especially I'm very glad to welcome Marka Frаймана, speaker of today's lecture. Mark is a well-known Canadian lawyer. He holds PhD from Stanford University, am I right? I think so. And he has a very great experience of legal work, both in legal practice. He served as in-house counsel of Air India. He was till last December, he was a partner of one of the biggest Toronto's law firms, Learners LLP. And in 2004, Mark was a Deputy Attorney General of Ontario, one of the biggest and one of the key provinces of Canada. And in this position, for 4 years, he had experience not only within Ontario, but within all Canada, because he was communicating, well, a lot of traveling and so on. Currently, Mark is involved, I think, in one of his biggest struggle of his life in Ukraine. He pays a lot of efforts for Ukrainian and Jewish mutual understanding, for the development of this issue. He is a part of Ukrainian-Jewish encounter, one of the leaders and contributors of which is Chen Stemarte, who was a sponsor of Sheptytsky Center, of its construction. I'm very glad that we have succeeded, because it was a long way. It was not one attempt to arrange Marka Fryman's lecture here at the UCU. I'm very glad that this lecture takes place at such symbolic place for the Ukrainian-Catholic University, for Ukrainian Jewish encounter, for Ukraine, a crossroad of mutually beneficial Canadian and Ukrainian cooperation. And on this, I'm very glad to pass the word to Mark. Mark, floor is yours.
Thank you very much. Вибачте, що буду говорити по-англійськи, but that's my Ukrainian. My other public service announcement is, for those of you who are unfamiliar, this is a tie. It's a primitive torture instrument that in the 20th century we used to require men to wear, and in the 21st century we don't often do that, but I wear it to remember the terrible times in the 20th century when men had to be subjected to this torture instrument. My subject today is human rights and democracy, and how one balances those two concepts. So let's strap ourselves in and let's see where we go. Human rights documents come in two different sorts. Some of them, like the Universal Declaration of Human Rights, are statements of principles with which those who sign them or those who adopt them say they agree and that they hope to obey. But the documents don't have any other binding force, which means there's no way to make those who have signed them actually obey them. Other documents, like the United States Bill of Rights, some European human rights conventions, and the Canadian Charter of Rights and Freedoms, are enforceable, either directly or indirectly, sometimes through special tribunals, like the European Court of Human Rights, or sometimes through the ordinary court system as in Canada, where individuals can actually enforce their own rights to the point that individuals can even have valid laws that the ordinary legislative process has enacted be declared by the courts to be of no force or effect. To some critics, this is a very difficult paradox. Overruling democracy in the name of some other value appears counterintuitive, even dangerous. If the people are not to be trusted to decide what is good for themselves, who is? And if judges are free to disregard the law and to tell others that they can disregard the law, then who can be safe? Now, to my mind, this is a false dilemma. And also to my mind, there's no better place than Lviv to look at this issue. I say this primarily because Lviv is in many ways one of the birthplaces of the modern conception of human rights. I don't have the time, and I hope there's no need, to elaborate on the contributions of Hirsch Laverpach and Raphael Lemkin, both of whom were natives of Lviv, and both of whom are in many ways the fathers of the modern conception of human rights, certainly of international human rights in the 20th century. For that alone, the city of Lviv can be very, very proud. But Lviv is also an appropriate venue because it was a prime setting for the events that required Laverpach and Lemkin's contribution to the field. I refer, of course, to the genocidal slaughter of Europe's Jewish population. In this region and in this city, that slaughter reached the staggering murder rate of over 90% of the pre-war Jewish population, which on average made up roughly 1/3 of this area's urban population. And of course, we have to remember that this murder was accomplished in an orderly and strictly law-abiding fashion, in which the victims of the mass murder were simply redefined as something other than human beings, so that the way they were treated fell under no known legal category and certainly under no known criminal legislation. This past Saturday, I attended Shabbat services in a small congregation that was literally in the shadow of the ruins of the once great Golden Rose Synagogue in Lviv. That synagogue was a masterpiece of Renaissance architecture that was blown up by the Germans in 1941, along with a mass of Jews who were forced inside and then the doors locked behind them. As you may know, it's customary on the Sabbath to read a portion from the Bible. The portion from the Bible that was read this Sabbath in the shadows of the ruin of the Golden Rose was from the book of Exodus, which coincidentally, if you believe there are coincidences, contains the following passage, which is addressed to judges. And I'm reading you from an English translation that follows the Jewish traditional reading of this passage. By the way, the name of the portion in Hebrew is Mishpatim, which means laws. So this Saturday we read about laws. And this is Exodus chapter 23, verse 2. You shall not follow the majority for evil, and you shall not respond in a lawsuit to follow the many, to pervert justice. neither shall you glorify a poor man in his lawsuit. I'll read it again. You shall not follow the majority for evil, and you shall not respond in a lawsuit to follow the many to pervert justice. Neither shall you glorify a poor man in his lawsuit. It's an instruction to judges that they not make a decision based on what the majority think is correct. And in a lawsuit, they not listen to false testimony, but look for the truth. In that last passage, I especially like, because it's an instruction that the class struggle is not the right way to determine a lawsuit. Just because one of the parties is poor doesn't mean you should find in favor of the poor person if justice is not on the poor person's side. Excuse me a minute while I get some water. To me, these passages are an early statement of the basic legal philosophic problem of an unjust legal system. Whether that injustice is on the basis of corruption, mob rule, a Robin Hood philosophy of taking from the rich and giving to the poor, or any other perversion of justice. And what I want to suggest in whatever time we have left today is that human rights and human rights codes are an important and necessary way to address this problem. And rather than indicating a democratic deficit, that is, a lack of democracy, human rights and keeping human rights standards, even to the point of nullifying legislation that doesn't comply with human rights, is a fulfillment of true democracy, because democracy necessarily includes freedom, and freedom necessarily includes human rights. Democracy without freedom is mob rule. So-called freedom without democracy is nothing but bread and circuses, or maybe I should say, vodka y Spartak. Lauterpacht and Lemkin's work in defining the concept of crimes against humanity and genocide were necessary for the International War Crimes Tribunal in Nuremberg. They provided a legal framework to allow the victorious Allies to prosecute those who violated the human rights of hapless civilians. That's fine. But how do residents of undefeated states protect their human rights from being violated by their own governments under less extreme measures, under less extreme circumstances? The 1948 Universal Declaration of Human Rights also arose from the same climate of revulsion at the horrors committed during the Second World War, and is a comprehensive statement of the rights that most civilized nations recognized as inherent, that is, innate human rights that all human beings are born with, and to which they have agreed. However, even before 1948, there was an equally comprehensive and well-worded statement of human rights that was signed and proclaimed by one of the states who also signed the Universal Declaration of Human Rights. And it was found in the Constitution of the Union of the Soviet Socialist Republics. And we all know how effective and how enforceable that document was. The problem, of course, was and is always one of enforceability. Words that stay on paper continuously lead to the concepts of human rights being brought into disrepute. States that are notorious as human rights abusers are often appointed as the chairs of international human rights commissions. Just last week, we heard in a certain Middle Eastern state an awards dinner for leadership in women's equality in the workplace, where each of 17 awards were given to men who were government employees. That's what happens when human rights stay on paper and don't get put into action and aren't enforceable. So, how do we reach enforceability? Let me speak for a little while about the Canadian experience and how Canada has tried to make human rights enforceable without going too far on the other side and turning human rights into something that it wasn't intended to be. Canada, as you may know, started life as a British colony, and so it followed the English common law system that was based on precedent as modified by laws passed by Parliament, which means by the legislature. After it obtained separate status in 1867, Canada continued the same tradition, more or less unchanged, for 115 years, until 1982, when for the first time, Canada put into its constitution a Charter of Rights and Freedoms. Now, a constitution, including a Charter of Rights and Freedoms, is a basic law that sets out the rules for what a government, including a legislature, can and cannot do. The idea of putting an enforceable limit on government action is a radical one. The English Magna Carta of 1215 was a radical constitutional document because it put limits on the powers of the King of England, something that previously had been thought only God or maybe a rival king could do. It was enforceable because, at least for a time, the barons who got together at Runnymede had a stronger army and more long-term resources at their disposal than King John did. Up to 1982, Canada had no equivalent to the U.S. Bill of Rights, that is, which is a series of amendments to the U.S. Constitution, and which the U.S. government had early on conceded was an enforceable document that the U.S. courts could enforce by means of decisions that would tell the government whether a law or its actions were consistent or inconsistent with the Bill of Rights. In Canada, by contrast, any defense of what we think of as human rights had to come from the laws passed by the legislature. If there was a law, the human right was protected. If there was no law, there was no protection. If the legislature chose to repeal a law that gave protection, the right disappeared. A judge who wished to protect what he or she thought was a basic right had to search through old cases to find something that he or she could apply creatively as a common law precedent. They weren't always successful, and even if they did find something, they were usually overturned by the Court of Appeal, who took a very dim view of what was called judicial lawmaking. Whatever else could be said, this was a system based on the rule of law and on the principle of democracy. Laws were made by a democratically elected legislature, and the judges applied the laws objectively and as they found them, not as they wanted them to be. If people didn't like the laws or thought they didn't reflect proper values, they could elect new representatives to pass new laws or to repeal old ones. There was nothing subjective, nothing arbitrary about such a system. At least, that was the theory. The 1982 Charter of Rights and Freedoms changed all that. As part of the fundamental law of Canada, the Charter takes precedence over all other legislation. What does that mean? It means that any law, whether new or already existing, any government action that's not consistent with the Charter is to the extent of that inconsistency of no force or effect. The principle is enforced by the courts, which means that a simple declaration by a court can make the law null and void, of no force or effect. Or a judge can reverse or even punish the actions of government or its agents where they are unconstitutional. Magna Carta conflicted with the idea of the absolute power of the king by forbidding him from doing things like raising certain types of taxes that he'd been able to do in the past, and shifted some of his power to members of the landed aristocracy. In much the same way, a basic law takes precedence over all other laws and conflicts with the notion of parliament or legislative sovereignty by forbidding the legislature from doing things like passing certain laws that it had been able to do in the past, and shift some of its power, like deciding whether certain types of laws should go into effect, to the courts. To the extent that a basic law grounded in the protection of human rights, like the Charter, works in a somewhat similar way, it forbids elected officials from doing what they say their constituents want to be done. And to the extent it puts the enforcement of that veto into the hands of judges who are not directly elected, it takes away from the democratic principle, at least in theory. Now, the truth is that values change over time, often much faster than laws do. Another truth is that not many elections are fought over the issue of whether it's a good idea or a bad idea that a given law seems to limit everyone's rights or that it limits those of a given group. It's also true that very few political parties advertise in advance all the potential human rights limitations that they're going to think about putting into effect once they get into power. And even less, if we are going to be realistic, is it possible to predict when you're voting for a candidate or a party which coalition that candidate or party is going to join and what the coalition is going to support for 3 or 4 years down the road. So even as a theory, some of the anxiety about the undemocratic nature of human rights law is a bit theoretical. But more basically, if the values being protected were uniformly, under all circumstances, and at all times popular, then there wouldn't be very much need to protect them by means of a charter. The idea of human rights protections is to protect important values against, in the words of Exodus, a majority wishing to do evil. It is precisely the so-called anti-democratic nature of human rights protections that makes them so very valuable. And that's why one has to realize that entrenching human rights in a constitution means that you are entrenching rights against the state. And while I said that putting the Canadian Charter of Rights and Freedoms into the Constitution shifted power away from the legislature to the courts, I was correct. The more radical shift is from the state to the individual. The individual now has a power to confront the state and say, you are taking away something that belongs to me, my human rights. And the individual has a forum in which the individual can bring that complaint. And this is the most important point that can be made, in a system where judges are truly independent, the individual has a hope of being vindicated in that complaint. In the Canadian Charter of Rights and Freedoms, that is why, on analysis, and I'll take you through the rights in a minute, the two basic rights, or the two basic values that come through an analysis of the rights that are given are autonomy and equality, and the third is democracy. You'll have to invite me back to give another lecture, because I can't go through the entire history of all of this, but I'll give you a nugget. Autonomy is my right to control myself in body and in mind. So long as I do not interfere with the rights and freedoms of others, I have the right to decide for myself all matters concerning what I think, what I say, and what I do. Equality in this context means that I am entitled to the same right as all others who are subject to the basic law, including the right to be treated without discrimination as to the application and the enforcement of the law and the protection of the law itself. Democracy means I have the same right as all others to decide matters of government that apply to myself. The Charter itself breaks down the rights that it enumerates into 7 categories, but I think the principles of autonomy and equality and democracy are especially useful to bear in mind when considering the following list of rights and freedoms protected by the Charter. I've broken them down, and this isn't the same breakdown as you'll find if you read it, but these are the essential rights. Freedom, freedom of expression, freedom of association, freedom of conscience, the right of citizens above 18 years old to vote, freedom of movement of all citizens, including the right to enter, remain, and leave Canada, the right to life, liberty, and security of the person, and not to be deprived thereof, except in accordance with the principles of fundamental justice, specific rights when one is arrested or detained, including a right to counsel, a right to know the charge against oneself, a right against compelled testimony, a right to a speedy trial, a right against cruel and unusual punishment, and finally, a right to equality before the law, under the law, and to the equal benefit of the law without discrimination. A guarantee of this range of individual rights shifts a great deal of power from the state. And there may be some force to the argument that in the wrong hands, protection of human rights can seem puzzlingly far from the advancement of anything but the most harmful version of autonomy, let alone anything resembling equality. To illustrate, in the United States, the Second Amendment to the Constitution, which is part of the Bill of Rights, guarantees a certain right to bear arms. It is often cited as a prime example of a rigid interpretation of a human right, interpreted in isolation from its context and used to defeat any sort of gun control, with the result that many residents of the United States feel that they have been denied the right of the assistance of their own government in being safe from harm where they live. And they in fact believe that being safe from harm is itself a type of human right. And so the right to bear arms has been interpreted by the United States courts in such a rigid fashion that measures to restrict the sale of automatic weapons, that is machine guns, have been found to be unconstitutional. So on the streets of major cities, you have people who are allowed to carry machine guns for God knows what reason. You can see, again, I say, in the wrong hands, a constitutional right to certain what are called human rights can be stood on its head and cause as much harm as it causes good. To me, this is more of a reminder that the entire concept of a basic law as a check on government infringement on a human right always depends on a truly independent court system presided over by a truly independent, non-political judiciary. Without having truly independent judges, the whole system can devolve into a system of abuse. Canada does not have an equivalent of the right to bear arms. And I won't go into, I've written out an analysis of the difference between American and Canadian interpretation. That's for graduate school in American constitutional law, not for me. Most important, though, is there is a mechanism in the Charter of Rights and Freedom that is entirely different from anything in the US Constitution and largely different from anything in European constitutions. It's Section 1 of the Charter. It says that the rights in the Charter are guaranteed and limited only to, and subject only to limits that are demonstrably justifiable in a free and democratic society. So, unlike the US Constitution, which puts no limits on the rights, the Canadian Constitution right up front says, yes, you can limit these rights. Now that sounds a lot like the European system because almost all European human rights documents say that they're limited. But the most European systems say that governments may reserve the right to protect public morals or public order. And in most of the jurisprudence, the courts give a lot of deference to governments to decide for themselves what's necessary to preserve public order or to preserve public morals or public culture. And the courts don't question the government when it says, no, this is necessary. I need to prevent people from seeing women's breasts. this is a terrible thing, we can't allow that, and it's pornography, don't tell me this is freedom of expression. Okay, fine, not our business. The Canadian Charter says demonstrably justifiable in a free and democratic society, and the courts take this very seriously. So, what does that mean? In order to be reasonable, the infringement has to be demonstrable. That means the government always has the burden of proof. If I'm challenging let me start. In the US, all I have to show is that what's being challenged is speech, in order for me to say my free speech has been infringed. Once I show it's speech, all the jurisprudence on freedom of expression kicks in and it's protected. In Canada, I show that it's speech. That's the first thing. The next step is it demonstrably justifiable in a free and democratic society? First question is, do I have to prove that it's not demonstrably justifiable? No. The government has to prove that it is demonstrably justifiable. So it has to demonstrate. It has the burden of proof. If it can't demonstrate, I win. How does it demonstrate? It first has to show that it has an important, socially beneficial objective in the law that's being challenged. There's an important reason why it's curtailing my right. First step. Second step, it has to show there is a relationship between the goal that it has shown and the infringement. There's some connection between the two. There's a reason why, in order to achieve better morals, they have to stop me from broadcasting the proceedings of American television shows. Third step, they have to show that there is no less restrictive means of achieving their objective. That they can't achieve the objective they claim by a different means that restricts the freedom in question less radically, less drastically. If there's a different means of doing it that doesn't involve curtailing the human right, then they can't curtail the human right. Even after that, they've done that, they have to show that the benefit from achieving the goal exceeds the harm from limiting the human right. And finally, even after they have shown all of this, they have to show that the final result is compatible with a free and democratic society. That this is the sort of thing that a free and democratic society can be proud of, that is not an embarrassment to democracy and to freedom. It is a very long list of requirements for the government to show in order to justify restricting a human right that's listed in the Charter. Nevertheless, there was still some controversy about this idea of stopping a valid law and of second-guessing democracy. And so there is an almost never used provision in the Canadian Constitution called Section 33, which allows a government, either of Canada or one of its provinces, to pass a law that says the charter, the effect of the charter is suspended with respect to a certain other law for a period of up to 5 years. The period of 5 years was selected because that's the maximum period between elections in Canada. That means you can pass a law that says the charter doesn't apply, but within 5 years you have to face an election. And the theory is you've told everyone in Canada that you are willing to disobey the charter. Now you have to justify it to the voters. Go ahead and justify it. After 5 years, the law falls away and it's now unconstitutional. So the next government is going to either have to pass a new suspending legislation, or the old law is no longer valid. I think I am not aware of any law that was contemplated that was actually passed, other than in Quebec about language rights, and that's a whole different story. So that's the framework. I think for the most part the Charter has been a success. It has expanded the right of the power of the court, but I think that hasn't provoked a great deal of outcry, and mainly because the courts are independent, and they are seen to be independent. Now, it's obviously true that the controversial cases are the ones that attract attention, and deservedly so. That's because they deal with issues that arouse a great deal of emotion, and that's what caused people sometimes to say, yeah, that's political correctness for you, with a sneer. Nevertheless, even in those cases, it's very seldom that you hear the government complaining about the result of the court decisions. I think that's probably, at least in part, because governments welcome the Charter and the courts. It's a very convenient way of getting rid of controversial issues. The government, and as Ivan said, I had some small role in government for 4 years. Attorney General in our practice means Minister of Justice. So I had my hands full with laws and constitutionality, and I know what politicians do. They hate to make controversial decisions. So if they can send a controversy to a third party, like the courts, and have it decided, and then say, what can we do? The court said this is what we have to do. We have no choice. They are more than happy to have somebody else take responsibility, because they know no matter what decision they make, they have 40 or 45% of the electorate going to be angry at them. But if they're simply implementing what somebody else tells them to do, their hands are clean. And the Charter has been great for them for that reason. I was very lucky. I had a chance to see the early development of the Charter from something of a front row seat. I was lucky enough to be the law clerk for the Chief Justice of Canada when the first wave of charter cases came to the Supreme Court of Canada. They were interesting. Those very first cases were kind of tame. In one case, the court said that it was unconstitutional for enforcement officers who wanted to search the premises of corporations to conduct a search without a warrant. Up to that point, it was thought that corporations didn't have a right of privacy, So you could just walk in and search the premises. And the court found that government officials had no right to enter any private premises whatsoever unless they had prior judicial authorization, and the search had to be supported by reasonable belief that the premises may contain evidence of a crime. And that's because the principle of autonomy includes a right to be left alone. And it's not just individuals. The government has no right to enter into your house or your company's house, into your backyard, into anything that belongs to you. Another case we looked at early on, the court struck down a requirement that corporate lawyers had to be Canadian citizens rather than just Canadian residents. In another one, the court ruled that a provincial law that required all retail businesses to be closed specifically on Sunday for religious reasons imposed a burden on all religions other than the Christian religions, because only the Christian religion observed Sunday as a holy day, and that wasn't permissible. It was a more complicated case than it seems. It had to do with who's responsible for enforcing morals, who's responsible for enforcing labor standards, but that was the general idea. In later years, there were more controversial cases. The Canadian courts have tackled, and therefore governments have managed to avoid cases about discrimination based on gender, age, religion, the whole gamut of possible discrimination. More contentiously, they've ruled that laws against prostitution were unconstitutional, laws against pornography, except child pornography, are unconstitutional, laws against same-sex marriage are unconstitutional, laws against medical marijuana are unconstitutional, laws against hate propaganda are constitutional. The list goes on and on. Most controversial, you remember when I said that people who were arrested or detained had a right to a speedy trial? The court held that a speedy trial means you have a year and a half from the time you were arrested to the time you come to trial. And the courts have ordered people who are undoubtedly guilty to be set free if they didn't reach trial within a year and a half. And it's caused a lot of controversy because criminals walking the streets, because the government was keeping them waiting for a trial for too long. That, I think, was the most controversial, much more controversial, actually by far the most controversial. One of the most interesting cases, and it shows you the principle I talked about, how times change quicker than laws. Times sometimes change quicker even than court decisions. One of the most interesting ones involved, and it depends on who's describing the issue, either the right to die, or the right to assisted suicide, or medically induced end to life. In a series of cases, the Supreme Court of Canada found that laws prohibiting or punishing that practice did, in certain circumstances, violate Section 7 of the Charter of Rights, which guarantees security of the person and not to be deprived thereof, except in accordance with the principles of fundamental justice, because it forced individuals to endure excruciating pain and suffering in circumstances where there was no hope for improvement or recovery and death was inevitable. As such, their autonomy was compromised. Nevertheless, the court went on. You see, there's Section 7 violation, but that doesn't end the matter. You then go to Section 1, and you consider whether it's nevertheless demonstrably justifiable in a free and democratic society. They went through the list of factors, and they concluded that the government's objective in protecting the vulnerable, who might be tricked into agreeing to this, or people who might recover and might actually not be dying, were important enough. And safeguarding against preventable deaths was an important enough objective, and there was no reasonable alternative means to do that, that the laws were nevertheless justifiable, and they held that those laws were constitutional. Within, I think it was 3, maybe 4 years, a new case came to the Supreme Court of Canada. They did the analysis over again. They looked at new evidence on the Section 1 question. They did the balancing again, and they said, with new medical science, new evidence, we now find that it's no longer demonstrably justifiable. They gave the government a year to work out new rules as to how to separate real cases from unreal cases, but they held that the law was unconstitutional. I don't know whether you want to hear about my cases, but I'll tell you a few cases that I've been working on. A month ago, the Supreme Court of Canada ruled in favor of my position on a case dealing with the rights of Canadian citizens living outside of Canada to vote in Canadian elections. You remember one of the rights was the right of every Canadian citizen over 18 to vote. The government had a law that said if you live outside of Canada and you've lived abroad for 3 years or less, you're entitled to vote the Canadian embassy. If you live for more than 3 years, you're not entitled to vote. The Supreme Court of Canada overturned that law, and I was very happy to see myself quoted as saying, nowadays with the internet and with modern technology, a Canadian living in Kyrgyzstan can know more about and be more connected to Canada than somebody living in Ottawa who sits by his fireplace and doesn't listen to anything. More importantly, to me has been the cases that deal with the balance between the human right of expressive freedom, which is protected by one section of the Constitution, and the right to be free of discrimination, which is protected by the equality provision. It's a very sensitive topic in the area of hate propaganda. Does the right of expressive freedom include the right to say hateful things about a group of people? If you ask in the United States, the answer is absolutely, because freedom of expression is absolute, and once you say something is speech, it's protected, no matter how horrible the speech is. If you ask in Europe, the answer is absolutely not. You say a few magic words, and the speech is unprotected. In Canada, of course, it's always more nuanced. If it's speech, prima facie, it's protected. But you then go to Section 1 and see whether the limit is demonstrably justifiable in a free and democratic society. I have to say that one of the most satisfying achievements in my legal career was being involved in the cases that definitively decided that hate propaganda, that is, expressions that arouse deep-seated emotions of hatred, that portray groups as being detestable with no redeeming virtues, are not covered by expressive freedom, and it is not unconstitutional to ban that sort of communication and even to punish people who engage in that sort of expression. So, Have I unmasked myself as not only a fan of undemocratic judicial activism, but also as an enemy of liberal democracy, of freedom of speech and personal autonomy? In words of one syllable or less, no. I said earlier that a constitution is a basic law that outlines the rules and the limits for the exercise of state power. In the case of Section 1 of the Charter, it in effect outlines the basic philosophy that underlies the allocation and limitation of government power that the Charter sets out. To use the words of Section 1, the Charter is designed to regulate and protect the workings of a free and democratic society. That is the basic assumption behind the Charter. The Charter is not neutral about what kind of society is acceptable in Canada. The Charter, and hence the laws of Canada, are not compatible with a society that is not free and not democratic. All three words are important: free and democratic. The human rights in the Charter are part of the basic law of Canada. They take precedence over all other laws because they are considered indispensable to freedom and to democracy. The values they embody, those of personal autonomy and equal protection without discrimination, are what make a society free and democratic. Whether something falls within a definition of one of the human rights enumerated in the Charter is assessed in light of the purpose of that right in a free and democratic society. Whether an infringement is nevertheless justifiable is tested with reference to the value between the benefit of the infringement and its negative impact on the values of autonomy and equality. Democracy is important, but democracy without equality before the law, under the law, and equal access to the law is a sham. Democracy without freedom from interference with autonomy is as impossible as so-called block attempts, even by temporary majorities, to cut back human rights and freedoms, while at the same time providing objective standards of evaluation that discourage any initiative to apply the Charter in an unequal way based on something other than the actual needs of a free and democratic society. Canada is hardly perfect. That's one reason it needs a Charter. The Charter is not perfect. That's why Canada must preserve its democratic tradition. Thanks. I'm glad to answer questions.
I just remember what you said about private property, that it cannot be violated. Right?
Yes.
My rights, so nobody reads my letters, which are in my desk, but if these letters are on my email. So I want to ask about like these new challenges of the internet epoch.
Well, I have to differentiate. Remember, I'm only talking about Canadian constitutional law. The Charter and the Constitution in Canada are only protections against the government. They're not protections against private individuals or against companies. So the government is not allowed to read your emails. And we have laws also that protect privacy. In order to invade privacy, you need a warrant. You need to go to a court, and you have to swear in information that gives evidence that there's a likelihood that there is something in your email that has evidence of a crime. As Ivan said, I wasn't in-house counsel for Air India. That's the only inaccuracy. I led a commission of inquiry, that is a government-appointed investigation as to how it was that terrorists blew up a flight of Air India in 1987. And so I got to understand intelligence also. There's a difference. Intelligence services can read your email also. They need a warrant too, but the requirements for what they have to show a judge, and it's a different judge and a different court, are a little different from what the police have to show in order to read your email. And again, that's national standards. There are, if the CIA wants to read your email, they do something different. And we now know that there are others who are going to be reading your email who don't care whether they have to go to court. It's not so easy, but the theory is you have a right to privacy, and a government that wants to invade that right to privacy needs somebody, a neutral third party, to say it's okay. And one of the terrible, terrible crimes against human rights in the 21st century is all of the governments, all of the agencies that ignore our human rights and decide we have no privacy and they can just take whatever they want from our electronic communications. And there aren't easy answers to that question.
Thank you for your lecture. It was really interesting. I have a question. Nowadays we are talking a lot about women's rights, and women now have a lot of quotas, like 50% in parliament or in some companies. Is it right to actually talk about women's rights and not about human rights? And doesn't it create inequality instead of create equality?
This was one of the big issues. Show my age. I was around when the debates were taking place about the content of the Canadian Charter of Rights and Freedoms and how to word the protections. And the most difficult issue was around equality and the effect of equality in women's rights and how to word it correctly and how to get the correct effect. In fact, in the Charter, there's a special section that says that nothing in the equality section should be read in a way to take away from government programs that promote equality for women or that promote equality for groups that have historically been disadvantaged. So the issue of quotas in the United States has been impossible to solve because it's the same issue as the Second Amendment and the right to bear arms. In the hands of the wrong people, rights turn into a way of denying rights. The right to bear arms turns into a way of denying the right to be safe. Equality rights turn into a way of denying minorities the way to achieve better access to things to which they've been, from which they've been shut out. Quotas aren't a great idea in theory, but and they have to be handled sensitively, because it's true. When you have a quota for women, that means that men who want to participate in something are denied access to a program. So if historically there hasn't been good representation of women, and we say we're going to reserve 50% of the places in this class for women, and there are many more men who apply than women who apply. Some men who may have better qualifications won't be admitted, and women with poorer qualifications will be admitted. By the way, that isn't what happens, because believe me, I've been on admissions committees and I know women always have better qualifications than male applications. Always, in every circumstance, for every position, in every university, in every school, without exception. It's just the way it is. And when men have more admissions, it is because of discriminatory qualification requirements. But it is true that quotas can work to the disadvantage of qualified people who don't have enough of a quota. But that becomes a philosophical question. If you don't give people a chance to make up for historic discrimination, you will continue the underrepresentation, and you will continue a pattern of effective discrimination. People will stay where they are and will never become integrated into the whole. It is a philosophical choice that has to be made. In countries like Canada, the Charter has made the choice when it says that nothing in this Charter affects the right to institute programs to improve the position of groups that have suffered from discrimination in the past. That's a political choice, and the Charter makes it possible to make that political choice without it being overruled as unconstitutional. But it is a political choice.
Я перепрошую українською мовою, задам питання. Останнім часом в Україні такі відбуваються процеси, як обрання суддів Верховного суду, антикорупційного суду. І тут постає питання таке доброчесності суддів. The problem of integrity of judges. Чи існує от така проблема в канадському суспільстві? Чи залучається, як у нас, до вирішення цих питань громадськість? Ну, у нас навіть, крім громадськості, і міжнародні експерти залучаються до цього. І це питання дуже актуальне для нас. Чи є такі східні процеси в Канаді, ну і взагалі як чесність, добропорядочність, така доброчесність суддів вирішується і в правовому, і в такому громадському розумінні? Дякую, містер Фрайман.
I understood right up to the end. Can someone just give me the... I know we're talking about judicial integrity, and the question is how that's handled in Canada. I'd like... Could somebody just give me the last half of the question? I need the last half of the question translated, please. I couldn't get my... Yes. Yes. in Canada, there is a body called the Canadian Judicial Council. It consists of the chief justices of each of the courts in Canada, so that would be the federal court and each of the provincial courts. They receive complaints either from the public or from lawyers or from other judges. The complaints are public, so everyone knows that there is a complaint. They appoint lawyers to represent the complainants, and they allow the judges who are complained against to be represented. They conduct an investigation, first of all, to decide whether there is anything to look into. Where they find that there is any sort of reason to look into the complaint, they hold a hearing. The hearing is held in private, but the complainant is represented, and the judge complained against is represented. They appoint a panel from the council to hear the complaint. There is a written decision that is handed down by the panel. The panel files its decision with the council. The council files a report to the Minister of Justice so that there's a record of it. If the complaint is upheld, and the council sends a recommendation to the Minister of Justice either to uphold the complaint or to not uphold the complaint. If the complaint is upheld, they recommend some remedial action, education, sometimes to demote the judge, to suspend the judge, or to fire the judge. They can't do that themselves. The Minister of Justice has the power to fire the judge, to demote the judge, or to do whatever. There have recently been a number of those cases, and some judges have been asked to resign. Some judges have been reprimanded. Many have been cleared of the offense. And it's usual that the public is informed of the nature of the complaint and the nature of the finding. And even minor issues are investigated. Because it was made public, I can tell you one interesting case. A member of the African Canadian community, a black man who his family originated from Jamaica, was a very prominent activist working for the advancement of the black Canadian community. He was appointed as a judge of one of the courts, and he maintained his position as a member of the executive of one of the organizations that promoted the interests of the African Canadian community. And that organization took a number of political positions about discrimination, about how the police treated the community. And a complaint was filed that it's improper for a judge to be associated with political positions. Even though they're nice political positions, it's wrong to be associated with it. A hearing was held. A hearing panel found that the complaint was justified. It's not appropriate. The judge was asked to resign from the positions on the panel, but not asked to resign as a judge.
Все, тоді дякуємо всім за те, що відвідали цю лекцію. Також нагадую, що запис цієї лекції та усіх інших відкритих лекцій в рамках UC Rule of Law Lecture Series можна побачити на сайті Школи права УКУ, а також на нашій сторінці у Фейсбуці. Також згодом ми анонсуватимемо усі наступні лекції в рамках цього проекту, тож слідкуйте за майбутніми анонсами. І до зустрічі в стінах Українського католицького університету.